I have spent 21 years as a court reporter. I have sat at the stenography station in more hearings than I can accurately count, and I have been very quiet while a lot of people said things that did not serve them well. I do not give opinions about cases. I do not speak to the parties. I type what is said. I am accurate, and I leave. The Delgado-Fenn construction dispute hearing on a Thursday in early April was assigned to Judge Harriet Voss, which I noted when I pulled the file that morning. Judge Voss had been on the bench for 14 years. She had a reputation among the court reporting pool that I will summarize accurately. She was patient, precise, and unimpressed by people who confused confidence with competence. The case was a commercial construction dispute. Delgado Contractors LLC had completed a renovation project for Fenn Property Holdings. Fenn Property Holdings had declined to issue the final payment, approximately $940,000, on the grounds of alleged construction defects. Delgado had sued. Fenn had countersued. The hearing was a pre-trial conference on scope and scheduling. Fenn Property Holdings was represented by a man named Waverly. He had 2 associates with him and a paracomputer file the thickness of a small dictionary. He arrived 16 minutes early, arranged his materials with a deliberateness that suggested he intended the arrangement to be noticed, and spoke to his associates in a tone calibrated to reach a bit further than necessary. The attorney for Delgado was a woman named Chen. She arrived 5 minutes before the scheduled start, said good morning to the clerk, and opened a single legal pad. Judge Voss took the bench at exactly 9 o'clock. The first 40 minutes were procedural. Document submission dates, expert witness schedules, the scope of the site inspection. Waverly had objections to the proposed timeline, which he raised in detail. Judge Voss heard each one. She asked clarifying questions. She ruled on each objection after hearing the response. Waverly received about a third of what he asked for on the scheduling points, which is typical in a pretrial conference of this type. The issue came up around the 10:30 mark when Waverly raised what he characterized as a threshold argument, that the scope of the dispute should be limited by a standard warranty clause in the original contract, and that this clause functionally capped Fenn's exposure and made a full trial on the merits disproportionate. He presented this argument with the specific energy of a man who has made similar arguments often and expects the room to orient around his analysis. Judge Voss listened without expression. Waverly cited 3 cases. He read the relevant holdings with some emphasis. He said at one point that he didn't want to belabor the legal analysis because he assumed it would be evident to the court. There was a pause. Judge Voss said, I appreciate the citations, Mr. Waverly. Which of those 3 cases do you believe is the strongest authority for your position? Waverly said it was the first one, a circuit court decision from a few years prior. Judge Voss said, Can you tell me the specific holding on the warranty cap point? I want to make sure I'm reading it the same way you are. Waverly said, The court held that standard construction warranty clauses are enforceable as written, and the parties are bound by the contractual limitation. Judge Voss said, And you're applying that holding to the clause at paragraph 14.2 of your client's contract with Delgado? Waverly said, That's correct, Your Honor, Judge Voss said. Paragraph 14.2 is a defect notification window, Mr. Waverly. It sets a deadline for written notice of a claimed defect. It's not a cap on liability. The warranty limitation clause, if you intended to rely on one, would be paragraph 17. Would you like to take a moment? The room was quiet. Waverly looked at his associates. One of them was already going through the contract. He said, Your Honor, I believe if you look at the broader context of that section, Judge Voss said, I have looked at the broader context. Paragraph 17 in your client's contract with Delgado is a limited warranty clause running 12 months from substantial completion. Substantial completion was certified 14 months before Delgado filed this complaint. I want to know whether you're arguing that the 12-month window bars all claims, because that's a different argument from the warranty cap argument you've been making, and I want to make sure I'm evaluating what you're actually putting before me. Waverly said, Yes, Your Honor, I believe that argument would, Judge Voss said. So you're conceding the warranty cap argument and shifting to a timeliness bar? He said, I would characterize it as a related point, Your Honor. She said, I'm going to characterize it as a new argument. I'll hear it. I will note for the record that the timeliness bar under paragraph 17 runs from substantial completion certification, and that the certification date in your own Exhibit D is 14 months before the complaint. You're going to need to address the discovery rule and any tolling arguments you have for the 2-month gap. He said he was prepared to address that. She said, Then let's hear it. He was not, in practice, particularly prepared to address it. The timeliness argument took about 20 minutes. He cited one case. Judge Voss asked him 2 questions about the tolling analysis. He did not have a clear answer to the second one. He said he would brief the issue more fully. Judge Voss said, "I'll expect a supplemental brief on the timeliness and tolling question within 10 days. Ms. Chen, you'll have 10 days to respond. We'll take this up at the next conference." She turned to the scheduling discussion and continued through the remaining agenda items without further difficulty. Waverly's energy across the second half of the hearing was materially different from the first. The deliberate volume had dropped. He made fewer unsolicited observations. He submitted on several scheduling points without argument. "I typed everything. I did not have an opinion about it. I am a court reporter." After the hearing, in the hallway, I heard one of Waverly's associates say to him, "You should have done the contract page through before we got here." Waverly said something quiet that I did not transcribe because I was no longer on the record. Chen was at the clerk's window when I passed. She was confirming the date of the next conference. She did not say anything about the hearing. The brief Waverly filed 10 days later was 41 pages. The response was 11. The court's ruling on the timeliness question came 3 weeks after that. The discovery rule applied. Tolling was established by the pattern of defect notification correspondence, and the timeliness defense was denied. The case was set for trial. I was not in the courtroom for that ruling. I heard about it from another reporter in the pool. She said Judge Voss's written ruling was 7 pages, clearly organized, and contained a single footnote. The footnote read, "Counsel is reminded that the warranty limitation and defect notification provisions are distinct clauses with distinct purposes, and that the confusion between them does not reflect the plain text of either." That footnote was in the official record. I typed the original hearing. My transcript was used to support the ruling. I have been a court reporter for 21 years. I do not comment on proceedings. I type what is said. But I will say this. Judge Voss asked very good questions. She asked them in the right order. She never raised her voice. She did not need to. The 14 years of preparation she brought to that bench made the 41-page brief necessary. It also made it insufficient. That is how the courtroom works when it works correctly. It is patient, it is precise, and it does not require anyone to raise their voice at all.